Hello and welcome to the Minimum Competence episode for Monday, April 13th, 2026. I'm your host for today, Andrew Leahy, an assistant teaching professor of law at Drexel Klein School of Law. On today's episode, ICE cracking down on birth tourism and a double dose of meta. A youth addiction lawsuit moves forward and ads recruiting plaintiffs get pulled. Let's remember, in war, you win or lose, live or die, and the difference is just an eyelash. And read today's legal news. On this day in legal history, April 13th, 1873, one of the most violent and legally significant events of the Reconstruction era unfolded in Louisiana with the Colfax Massacre. The conflict arose from a disputed gubernatorial election as competing groups claimed control of local government in Grant Parish. Black citizens, many of them formerly enslaved, gathered at the courthouse in Colfax to defend the Republican-backed election outcome. White supremacist militias, determined to overturn Reconstruction governments, attacked the courthouse with overwhelming force. By the end of the confrontation, dozens of black men had been killed, many after surrendering, making it one of the deadliest incidents of racial violence during Reconstruction. In the aftermath, federal prosecutors sought to hold members of the attacking group accountable under the Enforcement Acts, which were designed to protect the civil rights of newly freed citizens. These prosecutions led to the landmark Supreme Court case in United States v. Cruikshank. The court ultimately overturned the convictions, ruling that the federal government's authority to prosecute such crimes was limited. It held that the 14th Amendment constrained only state actions, not the conduct of private individuals. This interpretation sharply narrowed the scope of federal power to intervene in cases of racial violence and civil rights violations. The decision effectively left black citizens in the South vulnerable to attacks by private groups, as state authorities were often unwilling to prosecute perpetrators. It also signaled a broader retreat from Reconstruction policies, undermining efforts to enforce equality through federal law. For decades, this ruling stood as a major barrier to civil rights enforcement, shaping the legal landscape well into the 20th century. The legacy of Colfax and Cruikshank illustrates how judicial interpretation can either strengthen or weaken constitutional protections, particularly during periods of social and political upheaval. U.S. Immigration and Customs Enforcement, or ICE, has launched a new initiative aimed at investigating so-called birth tourism networks. These are groups that allegedly helped pregnant foreign nationals enter the United States on temporary visas with the goal of giving birth so their children obtain U.S. citizenship. The effort is part of a broader immigration crackdown under President Donald Trump's administration, which has emphasized stricter controls on both legal and illegal immigration. An internal ICE directive instructs agents to identify fraud and organized operations that may be facilitating these activities. While giving birth in the U.S. is not illegal, authorities are focusing on potential misuse of visas and false statements in applications. A 2020 regulation already bars individuals from using tourist visas primarily for the purpose of securing citizenship for a child, meaning violations could lead to fraud charges. The administration has also used birth tourism as a justification for attempting to limit birthright citizenship, a right grounded in the 14th Amendment. Trump issued an executive order seeking to deny citizenship to children born in the U.S. to non-citizen parents, but multiple courts have blocked the policy, and the issue is now before the Supreme Court. Government lawyers argue that birthright citizenship has encouraged an industry built around these practices, though data suggests such cases represent only a vanishingly small fraction of total U.S. births. ICE's initiative will focus on uncovering so-called fraud and dismantling organized networks, similar to past prosecutions involving birth houses that cater to foreign clients. However, the overall scale of birth tourism remains quite unclear, and officials have not yet indicated how many cases they even expect to pursue. The Massachusetts Supreme Judicial Court ruled that Meta platforms must face a lawsuit brought by Massachusetts Attorney General Andrea Joy Campbell. The lawsuit claims that Instagram was intentionally designed to be addictive for children and teenagers. This decision is significant because it is the first time a state high court has addressed whether Section 230 of the Communications Decency Act can shield a company from claims focused on platform design rather than user-generated content, which Section 230 protects platforms from liability for. The court unanimously found that the case can proceed because it targets Meta's own conduct, not the content posted by users. Specifically, the lawsuit argues that Instagram's features, such as notifications, likes, and endless scrolling, exploit young users' psychological vulnerabilities. It also alleges that Meta misled the public about the platform's safety and ignored internal research showing harm to teenagers. Meta disagrees with the ruling and maintains that the distinction between content and design is flawed, expressing confidence it will ultimately prevail. Meanwhile, the decision is part of a broader wave of litigation across the United States, with multiple states and plaintiffs accusing social media companies of contributing to a youth mental health crisis. Some recent cases have already resulted in significant financial penalties and verdicts against Meta and similar companies. You're getting a double dose of Meta today with a second development tied to the growing wave of social media addiction litigation. Meta Platforms announced it will remove advertisements on Facebook and Instagram that were being used by law firms to recruit plaintiffs for lawsuits alleging its own platforms are addictive to young users. The company said it is actively defending itself in thousands of ongoing cases and does not want attorneys using its services to find clients while simultaneously arguing those platforms are harmful. This move comes shortly after major courtroom setbacks, including jury verdicts that ordered Meta to pay millions in damages tied to alleged harms from youth social media use. The broader litigation landscape is large and still expanding. Thousands of cases are pending in both state and federal courts, many involving claims that platforms like Instagram were designed to encourage compulsive use and contributed to mental health issues among minors. Plaintiffs include individuals as well as public entities like school districts and states, which argue they have had to spend resources addressing the effects of social media on young people. Meta and other tech companies deny these allegations and maintain they have taken steps to improve user safety. The ads at issue are part of a common practice in mass tort litigation where law firms seek out large numbers of plaintiffs to build cases. These firms often work on contingency, meaning they only get paid if they win or settle, which creates an incentive to recruit clients through widespread advertising. Some attorneys criticize Meta's decision, arguing that blocking ads could make it harder for potential victims to learn about their legal options. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading and all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment and leave a rating or review on your podcast player, we sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here on Monday, and until then, remember, diplomacy is the art of telling people to go to hell in such a way that they ask for directions.